if we allow a private cause of action based on negligent behavior that is sanctioned by some statute, then a fortiori we should be allowing a private cause of action if it's based on willful breach of such statutes. And interestingly, and of course the restatement, as distinct from Thayer, doesn't speak of negligence, both the first and second. They speak of a wrongful act. There's room for both adjectives in that, negligent and willful. And interestingly, to the first cases that created the private action under 10b-5 at all, the Cardon-Gypsum case in 1946 and going on, this was so obvious, that is to say, that it should cover willful actions, that they never mentioned it. They just sailed right into it without any discussion of this distinction. But for comparative purposes, I think the distinction is important on the point I just made, namely the size of the circle, which has the benefit of the presumption that the willful violation of the statute provides a private remedy. Right? And of course, that immediately should bring to mind the class action, in this concept as well. Now I want to take a second step, actually further back, still in doctrinal terms. You'll recall the Bedrock Prudential doctrine formulated by Cardozo in New York in the Ultramarez case, namely that foreseeability of harm to a pretty specific third party was the only ground on which a defendant's negligent performance of a contractual duty, the audit of the company's financial statements, which was owed to the second party, the corporation, could possibly lead to liability to a third party, someone who justifiably relied on the performance of that audit and on the results that were then published by the corporation, by the second party. Now, whether so identified or not, I would say it's quite clear that this prudential concern animated the first step in cutting the 10b-5 remedy to its appropriate shape, namely that of Ernst & Ernst against Hochfelder, which denied the possibility of a negligent cause of action under 10b-5. Now, of course, it's a little odd. That case was also involved the negligent actions of a secondary tortfeasor, right? It was the accounting firm, not the corporation, that was charged. But the court wasn't focused on that. That comes in the third wave of rollbacks in the 1990s, and in this decade itself, 2000s, namely in the cutbacks that we now know, on secondary actors overall. But the issue, the prudential issue, why 10b-5 shouldn't cover negligence, if the people who suffered the harm were this broad circle, of harmed investors and so on, was of course a very important feature of the structure of the rule. I'll admit the court's approach to this in Ernst & Ernst was very textual. They really looked at the statute. But I would say the music of Ernst & Ernst, if not the textual analysis, the music was that of Cardozo and Ultramarez. And that creates an immediate and interesting a subject for comparative look. Then, what's the second policy problem? That comes about in a different foreseeability way, but also, oddly enough, with Cardozo, namely the Palsgraf case, right? And it is at this juncture when the music of Palsgraf, if not the citation, becomes relevant, that the modern course of rolling back the potential scope of the implied tort cause of action begins to bite. That's in the Berger Court, of course, in the 1970s. And I refer first, of course, to the blue chip stamp decision. I've always found that one of the most interesting ones to discuss with students because it actually is a very wide-ranging decision. It has an awful lot in it. It has a lot of history, a lot of policy, a lot of textual analysis. It's a pretty rich case because it essentially unearths these prudential considerations, right, which in that case led the court to say that since this is only an implied cause of action in the first place, right, we are going to presume that we have to cut back the circle, right, and we cut back the circle by saying that only those who transact, buy or sell, a security in alleged reliance on an alleged material misstatement have standing to bring the action. And I would say that is a straight, and therefore for comparative purposes, interesting common law evolution out of this Cardozo era, in this case, as I said, the Palsgraf era. Now, the same abuses, that is to say the evidentiary abuses that the court uses as kind of policy reasons for cutting down the standing to a narrower but still huge circle of people, they're the same whether you have a narrow circle or a broad circle. They speak of the abuse of the discovery process. They speak of the abuse of oral evidence, soi-disant statements of how I relied and so forth. Well, the same evidentiary abuses, of course, can and do exist if the only plaintiffs are those who transacted business, right? It isn't as if the quality of the evidentiary process changes with the limitation of the plaintiffs to those who transacted business. It's a straight question, I would say, of Palsgraf. That is to say, if you're going to hold people, but I'm going to make a criticism of that, if you're going to hold people to a liability for negligent behavior, they have to know, in a sense, to whom they are likely to be liable, because that's an important step in deciding to frame their conduct standards of behavior. Now, the thing that was a cheat in Blue Chip was that, of course, has to do with negligent behavior, right? There's no reason to think that you have to have a narrow standing circle of plaintiffs if it is a matter of willful behavior, right? The foreseeability of who will be harmed is a minor point compared to the willfulness of the act of putting out harmful information, material misstatements intended to cause people to rely on them to their detriment, right? So in a sense, Blue Chip, while it's an interesting use of this Palsgravian doctrine, is also an illegitimate use of it. And this is going to bear, I think, on the way that other nations begin to play with private causes of action in this field. Okay, now, in fact, note the following quotation, and this is from Blue Chip. I quote, well, I'm a little late already, I'm sorry. While much of the development of the law of deceit has been the elimination of artificial barriers to recovery on just claims, we are not the first court to express concern that the inexorable broadening of the class of plaintiffs who may sue in this area of law will ultimately result in more harm than good. In ultramaris, they should have used Palsgraf, but it's okay. In ultramaris, Cardozo observed with respect to liability in an indeterminate amount for an indeterminate time to an intermediate class and so on. So you see, this was very much in the minds of the court as it uses or misuses possibly these doctrines, which are doctrines all other civilian and other jurisdictions know, right, in shaping the remedy. Okay, now of course the most important, I better hurry here a little bit, the most important issue in the 1975 Burger regime was, of course, the conscious abandonment of Thayer's notion that it is the role of the court to decide whether or not a private remedy exists. The legislature has had no thought of that when it passed a regulatory statute, right? The classic case, of course, as all American students know, is Court against Ashe, where suddenly we have this set of standards or criteria which govern the question, is there a private cause of action? And only the first, namely whether the regulatory norm identifies a class for whose especial benefit, that phrase is in the court, was enacted. It then immediately undercut the significance of that criterion by requiring an inquiry into, quote, whether there was any expression of legislative intent. Well, that's a contradiction. I mean, either you are saying it is not our problem whether the legislature intended or not. Our job as a common law court, of course, is to invent the remedy. Then in Court and Ashe, they basically take away with the left hand what they had just given with the right. And so this is, in a way, what then, of course, happened with Reddington, Touche-Ross, and much others. I mention all these things because these are the elements of the private cause of action that have comparative significance as these causes of actions are developed. And they even have significance for the express cause of action, because not all elements of the remedy are necessarily identified when a statute provides for a private remedy. In a way, you said some of that, when you were speaking of the consequences of the statutory revision in Section 929 of the statute. Okay, now, second, our big problem is, of course, not insider trading. Our big problem is the problem of corporate misstatements. Willful, of course, have to be, right? And there the problems gave rise to a whole new set of concerns. The largest was, of course, the fact that the corporation, owned by many innocent shareholders, is now going to hurt those shareholders in their share value if the corporation has to pay a large judgment because incoming shareholders were defrauded to buy or outgoing shareholders were defrauded to sell, right? Now here, it is clear that the court put down, in a rather difficult case, a rule in favor of the private right of action, namely the Basic Inc. Court, the Levinson case. That case has had a very checkered history, but it is interesting that at the level of the class action, and this may be all I have now time to do and I should stop, at the level of the class action, checkered or not, right, and putting aside all of the other cutbacks, the causation problems of Dura, the pleading problems of Tell Labs, and so on and so forth, at the basic class action level, right, that concept has survived. Reliance was removed as an individual proof item in basic. Materiality has just been removed this week in a very split decision in the Amgen case as a individualized basis of relief. In other words, certification as a class action at least allows one step to be taken forward in the question of proof on these matters. I'm truncating a little bit my comments here, but in order not to get Marc more angry at me than he already is. But the point is, for me, all of these things need to be considered, right, in comparative terms by other jurisdictions beginning to go down the road of private actions. And they are quite different from those that are being discussed today. The opt-in or opt-out in the class, the contingent fee or other mechanism of compensation for the attorney, right? And so on. That's what you read a lot in the literature today about how these things should operate. I think there are in a sense deeper, maybe only doctrinal, but deeper concepts that need to be worked out also in comparative terms as other nations begin to see the beauty of some version of the class action, or as we begin to think of how to shape the class action in the wake of Morrison. Right? And with that, I think I'd better stop. So, thank you.
Good morning. I'd like to thank you, Frank, for having me here. This is my first time at your fine law school in Sacramento. It's just great. And it's also an honor to be on a program with you, Dick. It's my pleasure. What is the difference between California and Texas? Of course, there's many. The upside, of course, is that in Texas there is no state income tax. That is wonderful, needless to say. But based upon Frank's comments this morning, Frank was talking about Justice Scalia's most recent book. And it just so happened he co-authored that book with Brian Gardner, who's a member of the SMU faculty. And Brian and Justice Scalia gave a book roadshow at SMU a month ago, filled up the university auditorium to capacity. I'm speaking about 3,000–4,000 people, to a wildly enthusiastic audience, as enthusiastic as someone can be in this subject matter. I have a feeling the same would not occur here. For those of you who care to read about Morrison, I've just had an article published in the International Lawyer on the Morrison case. Very interesting case. Just one point about Morrison, about how to deal with the transaction test. is that the Second Circuit last year adopted the irrevocable commitment test with respect to determining whether a transaction triggers U.S. Scope under Section 10b. And the court basically said that if the United States is designated as the place of closing, and if title passes in the United States, then there will be Section 10b litigation in the United States. So in other words, I think this is important with respect to foreign transactions, that if lawyers wish to have the U.S. Be a place where the law is to be applied, then closing by the terms of the document can be made to occur in the U.S. with title transferring in the U.S. If not, then of course title is to be passed outside of the United States, and closing to be outside of the United States as well. My topic is comparative treatment of different jurisdictions, and what are some of the key issues? Some of the key issues are whether the jurisdiction recognizes a collective redress type of process. If so, is it an opt-in or an opt-out motto? For the students here, the opt-in motto is that the litigant must affirmatively decide to join the action, in other words, the prospective members of the class, and opt-out is that the prospective plaintiffs are deemed to be in the case unless they affirmatively opt out of the litigation. Another point is the recognition of contingent fee arrangements. And another key one is whether the jurisdiction adopts a loser pays motto or whether each party is to bear its own costs absent certain sanctions that may arise. And if a jurisdiction does adopt a loser pays type of framework or the disallowance of a contingent fee arrangement, then the next issue is whether third-party litigation funding is available. In other words, that a third party pays for the litigation costs in return for a share in any recovery that may be obtained. Let me begin with the United States as a background about what are the favorable aspects of class action treatment in the United States. The first is, of course, the availability of contingency fees here in the United States. This is how, of course, plaintiffs' lawyers get rich, and who are the envy of the big firm lawyers who normally represent corporations. I know that many of my former students at SMU have done plaintiffs' work and have become multimillionaires. I don't mean 5 or 6 million, I mean tens of millions of dollars doing all sorts of works ranging from asbestos in the old days to actually securities litigation. The next is in the U.S., of course, each party pays its own attorney's fees and costs. There's no loser pay system. A third is the liberal document and deposition discovery processes. Broad scope of discovery in the United States, broad range of taking depositions in the United States. Another is a trial by jury. As you can imagine, in many jurisdictions, including not outside the United States, but even in Delaware, findings of fact are issued by the judge, not by laypersons, especially in a complicated situation like securities law. And another key feature is the opt-out feature, that the litigants, prospective litigants, are deemed to be members of the class unless they affirmatively opt out. This is beneficial for both plaintiffs and defendants. From the plaintiff side is that you have an all-encompassing class. This is from the attorney's view. From the defendant's view, the defendants don't have to worry about add-on actions from members unless they affirmatively opt out. Now, what are the restrictions? Professor Buxbaum illustrated quite nicely many of them. You mentioned the Hochfelder case. And what really struck me about the Hochfelder case is that today it would be a non-issue. And why? Number one, the litigation was brought some 20 years after the fraud. So, of course, the statute of limitations would have expired because today there's a firm 5-year statute. And the second, at least reading the case, it seems like they brought the auditing firm in as aiders and abettors. And of course, since central bank was decided in 1994, there's no aiding and abetting liability. So the case wouldn't have even gotten near that far. It wouldn't have ever even been brought. I think what that illustrates in the last 20 years, and of course it goes back to 1974, 1975, but really within the last 20 years, simply how restrictive the U.S. securities laws have largely been, with some exceptions like the basic case, which happened to be, of all things, a 4-2 decision. Remarkable that the plaintiffs got incredibly fortunate in that the other 3 justices who are more pro-defense oriented were not involved in the case. But yet it is a decision of the court. The first, as I just mentioned, is the prohibition of aiding and abetting liability. And then coupled with that is the decision in Janus Capital just a couple of years ago where in order to be deemed to make a statement under Section 10b and Rule 10b-5, one must have ultimate authority over the content and dissemination of that statement, which means, for example, attorneys who draft a document are not deemed to have made a statement, that investment bankers who orchestrate a deal are not deemed to have made a statement, so that those who are potentially liable under Section 10b are far more narrow than was the case 20 years ago. Another example, which Professor Buxbaum mentioned, are the onerous pleading requirements. Many cases are simply dismissed at the pleading stage simply because the plaintiffs cannot muster enough to survive that motion. And note, under our system, under the Private Securities Litigation Reform Act, no discovery at all is permitted unless the plaintiff can survive a motion to dismiss. So yet there must be enough facts alleged to survive that motion without being able to procure any discovery. For our foreign visitors, it's not unusual for these plaintiffs' firms that have a good number of resources to hire private investigators to try to get enough from confidential witnesses to pass this muster. And also, interestingly, Dustin Hoffman's brother does this work at the Robbins Geller firm. I had dinner with him a few years ago, and he kind of looked like Dustin Hoffman, and he said, "Yeah, I'm Dustin Hoffman's brother." And he happens to be a graduate of UCLA Law School by chance as well. Very nice guy. And in the old days, with respect to bringing cases, a plaintiff could bring cases, could add on state law actions, could bring 33 Act actions and state law class actions. Today, because of the Securities Litigation Uniform Standards Act passed in 1998, with very few exceptions, class actions involving nationally traded securities, those securities traded in the NASDAQ Global Market and the New York Stock Exchange, must be brought in federal court with only federal law applying. So no state law claims are permitted whatsoever. Also, forward-looking statements, projections, and so on are treated much more protective of defendants than was the case 20 years ago. Today, if sufficient cautionary warnings are provided with respect to forward-looking statements by publicly held companies, those statements cannot be attacked in private litigation whatsoever. If enough cautionary warnings are not given, then liability can be procured only by showing actual intent. Very difficult to win with respect to projections today. And of course, there are also enhanced difficulties in proving loss causation and damages. Nonetheless, though, the U.S. is deemed to be an attractive forum to bring class actions. Let me just address some other jurisdictions from comparative viewpoints. The European member states, there are 16 member states that have collective redress schemes. Those major countries include France, Germany, Italy, the Netherlands, Spain, and the United Kingdom. But nonetheless, I think this statement is quite apropos from the Directorate General for Internal Policies of the European Union, and I quote, "While in general collective redress schemes provide added value and cost savings for consumers and business, they are not effective due to disparities and low participation rates." And why is that so? Generally for a number of reasons. First, there is the loser pays framework, where if a plaintiff does come out losing litigation, that party must pay the attorney's fees and associated costs. A second is that contingency fees are not permitted. A third is that there is no right to jury trials in civil cases in these jurisdictions. And a fourth is that there's very limited discovery that may be procured. And lastly, these jurisdictions follow an opt-in rather than an opt-out model, where members of the class must affirmatively opt in to the litigation. So a couple of examples that illustrate this. In the United Kingdom, there is the opt-in procedure, there is the loser pay system, and contingency fees are not permitted. Now, the United Kingdom does have third-party financing permitted to fund litigation so long as it does not threaten the integrity of the litigation process. I'm unsure exactly what that means, collusion or what have you, but nonetheless, there is some third-party funding that is occurring in the United Kingdom, and I gather that some suits are progressing. France, another example, is similar. It has a loser pay system, no contingency fees, an opt-in procedure, and discovery is very limited. Now the Netherlands, which Winfried will talk about after me, and I will just mention this for a moment, is deemed to be the most effective remedial collective scheme in the European Union. But it's nothing like the United States. For example, there are two types of collective action mechanisms in the Netherlands, and if I'm mistaken, I'm sure I will be corrected. At least I hope I will be. I'm married after all, so I get corrected every day. And that's fine, that's fine. The first is a representative group action vehicle. And note that the representative group action vehicle can only be used for injunctive or declaratory relief. It is not a damages vehicle. What it's used for is a springboard for follow-on private actions. The second is the collective settlement mass claims action, which is not a class action at all. It is a settlement approval procedure. So although the Netherlands is viewed as the most attractive insofar as plaintiffs are concerned, it is a far cry from what we have in the United States. Now, I just want to mention Japan, so I get out of Europe and Canada, and I'll talk about Australia. Japan, very little is going on. They've got their highest number of litigation deals with broker-customer disputes. They had 44 of them. Probably there's more than that in the Sacramento area in a year, I imagine. And they only had 7 cases from the last report during the last year with respect to misstatements, allegations against companies. So misstatements against companies, there were 7 cases in the entire country. So not a lot of litigation in Japan, collective action or otherwise. Let me turn to 2 jurisdictions that are more favorable, Australia and Canada. Australia, the class actions, they are recognized and they're increasing in number. As the Law Council of Australia has stated, and I quote, Australia is one of the few jurisdictions outside of the United States to adopt a legislative regime for the grouping of claims. Class actions have been described as something of a hallmark of the Australian litigation landscape. And like the United States, Australia has adopted an opt-out model. Whereby prospective plaintiffs are automatically included in unless they affirmatively opt out of the class. So what are the differences from the U.S.? One is that in Australia there is no initial class certification that is required. That the burden is placed upon the defendant to show that it is not appropriate for the plaintiffs to pursue the claim. So that's very helpful. However, unlike the United States, there is no fraud in the market theory, and plaintiffs, irrespective of a class action, must affirmatively prove reliance. And a third is that there is a loser pay system in Australia. However, third-party litigation funding, I gather, is becoming entrenched and is an available resource which is being used. And as stated in the brief of the government of the Commonwealth of Australia in the Morrison case, a lot of countries filed amicus briefs in the Morrison case. The government of Australia said, class actions are now a prominent feature of both the Australian legal landscape and the Australian psyche, Indeed, it is now said that Australia is the place outside North America where a corporation will most likely find itself defending a class action. Interesting also is that unlike the United States, the Securities Commission of Australia can bring class actions on behalf of allegedly aggrieved investors who don't have financial resources to pursue the action. And thus far, there have been roughly a dozen actions brought by the Australian Securities and Investment Commission on behalf of these investors as class actions. So that's very novel from what we have here. And what about Canada? Canada is really coming into its own with respect to class actions. There is no national securities law in Canada. Each province has its own securities law. Ontario, of course, is the one most looked after because that's where the Toronto Stock Exchange is, which is the prominent exchange in Canada. Canada, given the size of Canada, and the last statistics I have are for 2011, there are 15 new filings in 2011, with 24 active class actions involving claims amounting to around $16 billion. So it's very attractive. And let me just give a couple of examples of where Morrison has been rejected by Canada. In the IMAX litigation, the court certified a class action involving a Canadian company where the securities were traded on the U.S. NASDAQ and the Toronto Stock Exchange. So that plaintiffs were members of a class of both those who traded in the Toronto Stock Exchange and those who traded on the NASDAQ. Most recently, this just happened during this past year in the Canadian solar case, a case in which I was an expert witness. In that case, it was a Canadian company, an Ontario company, that issued press releases from Canada. It was really a company based in China. The company stock was only publicly traded in North America on the NASDAQ. Canadian purchasers purchased stock on the U.S. NASDAQ and then brought a class action in Ontario based upon violation of the Ontario Securities Act. The court recognized the claim as being entitled to go forward, and the jurisdiction was proper. So this was a case under Morrison, of course. Here we would have Ontario investors seeking to invoke Ontario law where the transaction occurred in the United States. So that's a very different type of treatment than in the United States. Very interesting. We're going to see more and more actions in Canada, and it's going to be a very ripe type of situation. In fact, there are plaintiffs' law firms now in Toronto who make their living by bringing these cases. Very interesting. Let me explain why, just for a few minutes, if I may. One is that although a number of Canadian provinces have a no-cost regime like the United States, Ontario does have a loser-pay system. However, third-party litigation funding is common in Ontario, and it does not appear to pose a barrier to bringing these claims. Secondly, there is no burden to prove fraud with plead fraud with particularity, as is the requirement in the United States under the federal securities laws. All that must be done is that the court is satisfied that the action is brought in good faith and there is the reasonable possibility of recovery. So it's a very low burden, far below what the Private Securities Litigation Reform Act requires. Next, there is no scienter requirement with respect to core documents in Canada, for example, in Ontario. In other words, if there are false financial statements, the burden is upon the defendant to show its good faith, its due diligence, like a Section 11 cause of action. The burden is upon the defendant to show reasonable care. No scienter finding. Thirdly, no reliance requirement. Reliance is a non-issue in Ontario. Not even rebuttable. Non-issue. No reliance in the cause of action. Fourthly, no burden upon the plaintiff to show loss, causation, and damages. This is looking very good for plaintiffs, just like Section 11. In other words, just like Section 11, which deals with false registration statements, that the burden is upon the defendant to show that the change in the price of the security was based on factors other than the misrepresentations at issue. Now there is, and this is quite sensible in my view, there is a cap on damages. The issuer is only liable up to the greater of $1 million or 5% of its market capitalization. Similarly, there is a cap on damages on directors and officers, unless actual knowledge is shown. And if actual knowledge is shown on behalf of those officers and directors, then no cap applies whatsoever. So with these types of provisions, is it any wonder that Ontario is going to see a lot of class action litigation? And it's going to be a very interesting process, and I really think the real subject of comparative treatment today, at least for those who favor a more expansive view of U.S. securities law, is to compare what's going on in Ontario versus what's going on here, how the settlements are being posed. These cases are being settled with regularity, and one law firm, the one that retained me, is called Siskins, which is based in Toronto, and it has a very attractive class action practice, and it's a very interesting situation that's happening in Canada. With this, I'll stop, and thank you very much for having me here. It's been my pleasure. Thank you.
Let me see. Good morning, ladies and gentlemen. My name is Winfried van Muijsenbergh. Indeed, an unpronounceable name in any other language than Dutch. And the same goes for the Wet Collectieve Afwikkeling van Massaschade. That's the Dutch Act on the Collective Settlement of Mass Claims. I have a PowerPoint, but the question is, how do we proceed to have it available? Well, somewhere in the machine.
This thing has gone to, it's gone dormant. Is this on foot?
Anyway, while Frank is doing the technical assistance, I would first like to thank Frank for having invited me. I'm a practitioner, legal practitioner. I always feel humbled in the middle of real lawyers, legal brains such as Dick Buxbaum, Mark. So I hope that you will not be disappointed, because the focus of my presentation is indeed a more practical one. Yes?
Okay. We're finding the secret password here.
The secret password. Okay. Anyway, as you already understood, the Netherlands do not have class actions. That is the disappointment. But nevertheless, we can bring some good news to the Aussies that Frank was referring to, who were left out after Morrison, because under circumstances they might be, well, of course they're always welcome in the Netherlands, and under circumstances we might offer them a solution. Under circumstances, because the first question remains how to beat the tortfeasor into submission. And unfortunately, and I don't have anything to add, what just was explained to you, the Dutch legal Code of Civil Procedure does not offer many opportunities. There is no discovery indeed in the Netherlands. There is a very limited possibility to get depositions. An American might find it odd, but witnesses are heard by a judge, and the judge dictates the statement, so no court reporters, no literal transactions. So in order to bring someone to the next stage and to offer a settlement,